If you currently hold a green card, or if someone close to you received their lawful permanent resident status within the past few years, you need to pay very close attention right now. USCIS, the United States Citizenship and Immigration Services, has made an announcement that is sending serious concern throughout immigrant communities nationwide. The agency is reopening and re-examining green card cases that were already approved. And if you are wondering whether this could impact you, your spouse, your parent, or a friend, that is exactly what we are going to carefully and clearly explain today. If this is your first time here, this channel focuses on immigration updates that are factual, current, and presented without unnecessary drama. Today, we are addressing one of the most substantial enforcement changes in years, so let us walk through it step by step. Recently, USCIS Director Joseph Edlow issued a direct and unmistakable statement to green card holders across the country. He announced that the agency is intensifying enforcement and revisiting previously approved cases, including approvals granted in earlier years. Let that sink in for a moment. These are cases that were already decided. Individuals who already received their green cards, who have been working, raising families, building careers, and planning long-term futures in the United States. Those cases are now subject to renewed review. In a public communication, Director Edlow confirmed that USCIS is opening additional tip lines so individuals can report suspected immigration fraud. He also noted that USCIS is working closely with ICE and Customs and Border Protection to coordinate enforcement efforts. He specifically warned that if fraud occurred in the past, the agency would investigate and address it. Those are strong words. And for the overwhelming majority of green card holders who went through the process honestly and lawfully, those statements can understandably feel unsettling, even if they are not directed at you. That is why we are breaking this down today. Understanding what is happening and what it actually means makes a major difference. Let us begin with the legal foundation. Why is this happening now? What authority does USCIS have to reopen approved cases? This broader review effort is part of a larger federal initiative aimed at closing loopholes, preventing misrepresentation, and ensuring that only eligible applicants receive permanent resident status. USCIS has made clear that it is reviewing older approvals, including cases granted in recent administrations where fraud may have been involved. If inconsistencies or intentional deception are uncovered, USCIS may move to revoke permanent resident status. This marks a noticeable shift from prior practice, where approved cases typically remained untouched unless problems surfaced later. Here is an important clarification. The authority to revisit and rescind a green card is not new. This power has always existed under U.S. immigration law. According to long-standing USCIS policy, the agency must serve what is called a Notice of Intent to Rescind, often referred to as a NOIR, within 5 years of the date that a person adjusted status to lawful permanent resident. That 5-year limit is established under Section 246 of the Immigration and Nationality Act. This means that if your green card was approved more than 5 years ago and no fraud or misrepresentation has ever been alleged, you are in a significantly stronger legal position. That 5-year time frame matters. However, if your green card was granted within the last 5 years, particularly between January 20th, 2021 and the present, this review initiative may directly concern you. USCIS has stated that it is re-examining approvals issued since January 20th, 2021. Some cases may require additional interviews as part of that re-review process. That timeframe encompasses millions of individuals who were granted lawful permanent residency during that period. Let us also look at which groups may be facing closer scrutiny. A policy memorandum issued on January 1, 2026 expanded processing holds and re-reviews for individuals connected to 75 countries identified under Presidential Proclamations 949 and 109998. That memorandum placed adjudication holds on certain pending and future benefit requests. Even cases that appear fully approvable may be paused at the final decision stage. For individuals whose green cards were already approved, USCIS has begun re-examining every green card granted to individuals from countries designated as high risk under these proclamations. That is a substantial operational change. Now you may be asking, what exactly is USCIS looking for during these reviews? The agency has been very clear about its focus: fraud and material misrepresentation. Investigations are centered on cases where fraudulent documentation may have been used, where information was intentionally withheld, or where eligibility criteria were not truthfully met. This can include sham marriages entered into solely for immigration purposes, falsified employment records in employment-based petitions, fabricated supporting documents, or failure to disclose prior criminal history. Since January 20th of the previous year, USCIS officers have made more than 29,000 fraud referrals to the Fraud Detection and National Security Directorate. That division completed investigations on more than 19,300 cases and identified fraud in approximately 65% of those investigations. These numbers show that enforcement efforts are active and ongoing. USCIS is also coordinating closely with ICE and CBP to strengthen investigative procedures. This interagency collaboration significantly expands enforcement capacity. It indicates that this initiative is not temporary. It reflects a structural shift in how immigration enforcement is operating. Now let us address what happens if USCIS takes action in your case. This is where due process becomes crucial. Individuals have rights. If USCIS determines that lawful permanent resident status should be reconsidered, the agency must issue a notice of intent to rescind. This notice must explain the reasons USCIS believes the individual was not eligible for permanent residence at the time it was granted. It must clearly outline the person's rights and available options during rescission proceedings. The notice must be delivered by certified mail with return receipt requested or delivered personally. It cannot simply appear as an informal message or email. There is a formal legal process. Once served with a notice of intent to rescind, the individual has 30 days to submit a sworn written response and may request a hearing before an immigration judge. That 30-day window is critical. If you ever receive such a notice, do not delay. Do not set it aside. Every day matters. During a rescission hearing, the immigration judge has authority to determine whether permanent resident status should be rescinded. If the judge rules against the individual, an appeal may be filed with the Board of Immigration Appeals within 30 days of the written decision. There are multiple procedural safeguards built into the system: formal notice, an opportunity to respond, a hearing, and appellate review. Lawful status cannot simply be taken away without an opportunity to contest the allegations. That said, immigration attorneys have cautioned that even minor technical inconsistencies from older filings may resurface during review. This is particularly relevant for communities that navigated complex employment-based processes with extensive documentation histories. So what can you do right now? First, gather and organize your immigration records. This includes your green card, approval notices, original petitions, adjustment of status filings, any requests for evidence you received, and your responses. Keep both physical and digital copies in a secure place. If you worked with an attorney, confirm that your file is complete and accessible. Second, update your address with USCIS immediately if you have moved. When USCIS serves a notice by mail, service is considered complete on the date it is mailed. If a notice is sent to an outdated address, the response clock may still run even if you never received it. Keeping your address current is essential. Third, conduct an honest review of your original application. Reflect on what documents were submitted, what information was disclosed, and whether there were any omissions or inaccuracies. If you believe there may have been errors, even unintentional ones, consult a qualified immigration attorney now, rather than waiting until you are responding under pressure. Fourth, if you are from a country designated under current presidential proclamations, monitor correspondence closely. USCIS has increased social media vetting, community interviews, and financial background checks as part of enhanced screening measures. Fifth, avoid posting unnecessary immigration details on public social media platforms. USCIS has confirmed that social media screening is part of its fraud detection and security review processes. For those assisting elderly parents or relatives who recently received green cards, check in with them. Ensure their address is up to date. Confirm that someone trusted has access to their documents. If they receive certified mail from USCIS, review it promptly and seek professional advice if needed. For newer arrivals, this situation reinforces an important lesson. Documentation discipline matters. Keep copies of every form submitted, every notice received, and every communication exchanged with USCIS. A well-organized paper trail is one of your strongest protections. To stay informed about your case, you can use the USCIS case status tool at uscis.gov with your receipt number. If your case is subject to a processing hold, you may see limited updates, but checking regularly ensures you do not miss critical changes. USCIS also provides an e-request system and a contact center for certain inquiries. If you determine that professional guidance is appropriate, seek a licensed immigration attorney or an accredited representative. Accredited representatives can be located through the Department of Justice's Executive Office for Immigration Review website. Always verify credentials before paying anyone for immigration assistance. A final word of caution. In times of heightened enforcement, scammers often exploit fear. Immigration consultants who are not licensed attorneys cannot provide legal advice. If anyone guarantees protection of your green card without proper credentials, that is a red flag. Protect yourself by working only with licensed professionals. Immigration policy in the United States changes frequently and sometimes rapidly. The information presented here reflects official USCIS guidance, DHS policy memoranda, and verified reporting from reputable sources as of April 26, 2026. However, your situation is unique. This video is educational content, not legal advice. Clear, accurate information is your strongest defense in a changing immigration environment. If this explanation has helped you better understand what is happening, consider sharing it with someone who may benefit. Staying informed is not optional in times like these. It is your most powerful tool. Take care of yourself. Stay organized. Stay alert. Know your rights.